Good morning, everyone. Thank you for joining us today as we embark in this exploration of the European Union Artificial Intelligence Act, also known as the AI Act. I'm Arnaud Latil from Sorbonne University and Sorbonne Center for AI, and I have the great pleasure to organize and to present this webinar this webinar. I organized this webinar with my colleague Marion Audac from Artois University. Will be moderate the next webinar on the 17th of December. We are standing today at the heart of the European Commission and in the DG Connect, which hosts the AI office. And we also have the great pleasure to welcome members of the AI office today with us. So Kilian Gross, welcome. You're the head of unit at DG Connect Unit A2, which deals with the AI and regulation and compliance policy. So you're in charge of the implementation of the AI Act. Welcome. Irina Orsic, welcome. You're the head of sector for governance and regulatory, and you are working on AI regulation from a long time. And then Laura Jugel, welcome. You're a legal and policy officer in Kilian's unit, and you are closely working with EU member states. All of you were closely involved in the preparation and negotiation of the AI Act. Thank you for being with us today. This webinar is part of the AI Pact. Just a few words about the AI Pact. AI Pact is an initiative launched by the Commission in last May in order to interact directly with stakeholders regarding the AI Act, which entered into force on last 1st of August. We'll discuss the rationale of this text and the main provision of the AI Act in order to give clarity for everyone as we have embarked on a demanding implementation period. This seminar will be divided in three parts. Three main points. The first part of this webinar will be dedicated to the Act objective and architecture. The second part will be dedicated to the risk-based approach adopted by the Act, and the third part will focus on governance framework, which the AI office is obviously a component. And we aim to make this session interactive, so therefore each session of three parts of the webinar will be following by a Q&A session using the Slido application. So now you are supposed to see a QR code on your screen to connect to Slido, and the hashtag for the Slido is AIinEurope. So connect to Slido and feel free to participate and to ask a question at the end of each of the three topics. But before we dive into this agenda, let's start with a short video from Lucilia Scioli, director of the AI office, who has recorded a brief, short welcome message for us.
Good morning. I'm delighted to be here today to open the AI Pact webinar and welcome you to this possibility for engaging directly with some of my colleagues responsible for the implementation of the AI Act. Together, you will explore the objectives and the structure of the AI Act, its risk-based approach, its governance framework, and of course, the European AI office that I lead as a director. The AI Act came into force on the 1st of August this year and has attracted a lot of interest about its implementation, its impact on citizens, businesses, and public services across the EU and beyond the EU. This is why these webinars are so important to us in the AI office. We are organizing them as part of the AI Pact, an initiative launched by the European Commission in May. This policy is designed to support early compliance with the AI Act, which will become fully applicable in 2 years. It also aims to identify and share best practices. For us, the Pact represents a strong commitment to helping businesses and organizations navigate the implementation of the AI Act. It is also a call for collective action within and beyond Europe. The AI Pact has already proven to be a success. To date, over 1,400 organizations have joined its first pillar, which fosters a collaborative community where participants can share experiences, best practices, engage in webinars like this one. And the second pillar promotes early action aligned specifically with the objective of the AI Act, where companies can pledge certain commitments, and we already have 130 companies, including multinationals, but also SMEs, committing to early compliance with the key provisions of the AI Act. These companies span all the sectors of the economy, from IT, telecoms, healthcare, banking, automotive, and aeronautics. And the AI Pact offers a unique opportunity for us to engage with many organizations, as you will do today with my colleagues, to discuss the key aspects of the AI Act. After today's session, and the second one in December, we will continue with a series of more focused webinars starting in 2025, at the beginning of 2025, and aligned with the implementation agenda. Under my leadership, the AI Office is committed to building on the feedback and the interest that you share with us through these webinars. Before you all start, I also like to extend my gratitude to our experts, Arnaud Latil and Marion Audac, who will be moderating today's session and the upcoming webinar in December, respectively. So I thank you for your interest. I wish you an excellent webinar, and I look forward to seeing you in the next ones. Thank you very much.
Okay, following this word from Lucia Scioli, let's move to the first part of this webinar dedicated to the Act objective. So the European Union has made it clear that it wants to aim the leadership, a global leadership on AI, and especially in responsible AI and trustworthy AI. So the three main objectives of the text are building trust, fostering innovation, and protecting citizens' rights. So let's dive to the first part, building trust. So my first question is for you, Kilian, about trust. How is the EU aiming to build trust in AI?
Well, thanks a lot for this question, because trust is indeed the key feature of this legal text, because we want to create an internal market for AI, but for AI which is trustworthy. And we do this by setting up a product framework for AI. So we treat AI, that's the first message, we treat AI as a product which we want to make safe. And I think we have in Europe quite a tradition of making good products like cars, medical devices, and now we look at AI and we will use the same mechanism to make AI successful but safe. This regulation is horizontal, so it will touch on all AI. That's another important point. So we don't distinguish between AI being embedded in the product or being used in a social context. It is, and we have clear criteria how we want to make this safe. And the objective of the Act is to protect fundamental rights, safety, and to create by this trustworthiness. By doing so, we want to create trust along the value chain. And this, of course, requires as well transparency. So we put a lot of emphasis in the AI Act on transparency, be it transparency between the provider and the deployer of an AI system, be it transparency by using generative AI, or be transparency for a provider of a general purpose AI model vis-a-vis the downstream provider or the AI office.
Okay, thank you. And regarding the two other objectives, now Irina, can you tell us about the history of the Commission action on AI?
Yes, we started a long time ago in the early 2000s with supporting research projects in AI and robotics. And AI was always on the screen as something to be supported. But then we entered more in the policy debate from 2017 and came out with the first strategy on AI for Europe in 2018 based on 3 pillars. So we have the innovation and the competitiveness, we have the socio-economic questions, in particular with regarding to the future of work, and we have all the ethical and legal questions. And ever since then, our policy was based on the question of innovation, competitiveness, legal, ethical, and we always considered this to be 2 sides of the same coin. So we had a high-level expert group to give us some advice on trustworthy AI, having guidelines, but they also gave us advice on how to foster competitiveness. We had the white paper having the 2 of them. And now we're having the AI Act, but we're also having a strategy on generative AI, and we'll be putting forward a new strategy soon.
Could you tell us a bit more about this high-level expert group on trustworthy AI you just mentioned? What are the relation with the AI Act? It was an inspiration for the legislator?
Yes, absolutely. So there we got 52 experts from industry, from civil society, from academia, so really everybody around AI, and they were discussing ethical principles for trustworthy AI. And out of these principles they then put forward to us, actually this is really one of the fundamentals of the AI Act. Indeed, we had to transpose them into legal language, into legal things that are actionable, but a lot is based on their work.
Okay, and regarding fostering innovation and protecting citizen rights, how the text interacts these 2 objectives?
So innovation is absolutely key. And let me just say before, if something happens with an AI, you're liable anyway, with or without AI Act. But the AI Act helps you to design a high-risk AI in a way that avoids liability. So it creates a legal certainty. Legal certainty is clearly a factor for innovation. Then all the requirements we are having in the AI Act to have this legal AI are going to be standardized. So once the standards are there, it will be relatively easy to implement. And then we do have something I think we're really proud of in the AI Act, the regulatory sandboxes. So the possibilities for companies, for AI providers to develop jointly with the regulator their AI in conformity with the law.
Okay. We'll talk later about how the AI Act deals with fundamental rights, privacy, but first let's go to another topic about the AI architecture. And now, Laura, I have a question for you about the architecture of the text. The text is quite massive and complex, more than 100 articles, 200 recitals and 13 annexes. It's a massive text. So just to have a short overview of the text, could you explain us what are the main building blocks of the text, Laura, please?
Yes, indeed, happy to. And you are very right. It's a very comprehensive document, 113 articles, some of them with as many as 10 paragraphs. So the way the AI Act is built is very common to EU legislation. We start out with general provisions in which we set out the subject matter, the objectives, the definitions that apply for the text. And within our general provisions, we also have one article that concerns AI literacy, because that is also horizontal. Then we enter into the next block, which are the rules that will apply for providers and deployers of AI systems and of general purpose AI models. Starting with the prohibitions, then obligations that apply in relation to high-risk AI systems and also the classification of them, the rules related to transparency, and finally the block on obligations for providers of general purpose AI models. So that's the block with the substantive rules. Then we have the block that you've just touched upon that concerns innovation, where we set out the conditions for AI regulatory sandboxes, for real-world testing of high-risk AI systems, another possibility to, or another regulatory tool we have integrated to support innovation. And we also include a couple of support measures for small and medium-sized enterprises and startups, some derogations from the obligations. So that's all the block on innovation. And then finally, of course, we have a block that sets up the governance, because rules always come with a supervision and enforcement scheme. And there we attribute the responsibilities of the responsible authorities, the powers that they will have, the powers that the AI office will have for some parts of the AI Act. And also, because governance is more comprehensive than just enforcement under the AI Act, the advisory bodies. And then very finally, the text closes with some final provisions that are about keeping the AI Act up to date, the fines and the entry into application, about which we'll talk later.
Thank you, Laura. Now let's turn to the interplays between the AI Act and other key EU regulation. It's a very important topic. I'm sure a lot of people are asking themselves about the interplays between, on the one hand, the AI Act, and on the other hand, other key EU legislation which apply to AI, as the GDPR, the DSA, on the DMA, on copyright law, cybersecurity law. So this is a question for you, Laura. What are the relationship between, on the one hand, the AI Act, and on the other hand, all the other legislation on AI, on the side on AI?
Kilian mentioned already that the AI Act will apply horizontally, so it applies across all sectors. And when designing the AI Act, this was a deliberate choice. We already had a lot of product, or we have product safety regulation out there. And designing the AI Act as a horizontal product regulation allowed to have a complementary interplay with them. So to the extent the AI Act will apply to products that are already regulated by product regulation, there's a harmonization of procedures.
The GDPR and copyright law.
Indeed, so that's the one dimension.
Yeah.
The second dimension is, of course, as you mentioned, the digital rulebook, which we already have. Mm-hmm. To set it out, the AI Act is without prejudice. This means all of these other regulations, they will continue to apply. The AI Act has been designed to be complementary to the GDPR, to the digital rulebook that includes the Digital Services Act, the Digital Markets Act, and mutually reinforcing. And you see this throughout. For example, for the Digital Services Act, there's a huge interlinkage when it comes to the question of generative AI, transparency around AI-generated content. Obligations that are being put forward under the AI Act will support the effective enforcement of the Digital Services Act. When it comes to the GDPR, we foresee special cooperation provisions and the interplay in data access requests between authorities that enforce, on the one hand, the General Data Protection Regulation, and on the other hand, the AI Act.
Okay, thank you. And so, in addition to this relationship, the AI Act relates with the new legislative framework. The new legislative framework approach is well known from stakeholders, but I'm not sure that AI experts are really aware of this regulation. Could you, Kilian, explain us what is the new legislative approach and how does it interplay with the AI Act?
Well, the new legislative framework is an approach which is not so new in the Commission, if one is honest, which we use since the late 80s, because we do not want to prescribe in detail technical requirements in legislation, because technical requirements move on all the time and change, and this is, of course, in particular true for digital products. Therefore, in the new approach legislation, what you have is rather high-level requirements, which are then underpinned with standards. And the standards are developed in a co-regulatory approach, and they are adapted over time. So this is much more flexible, much more agile. The new legislative framework is indeed the core of the regulation. We have as well in Annex 1, Section B, a little section on old approach legislation, but there we basically modify the sectorial legislation. So what do we do now is we basically, I mentioned already, we follow the product-based approach. So we treat it as a product that has a few consequences. It means that the provider, so the one really developing and bringing the AI to the market, has the bulk of the obligations. He or she has to make sure that the product, the AI, is safe, that it complies with the requirements which are then further explained in the industry standards. He or she has, and as a consequence, the deployer, the one using the AI, has a rather simple set of rules, so he can rely on this. The deployer, the provider, has to make sure that the requirements are fulfilled by doing an ex-ante, carrying out an ex-ante conformity assessment, where the compliance with the 5 requirements is checked. This can be a self-assessment, or this can be an assessment by a notified body, by a third party, as we say. As a result, he receives a CE label. And this is a big advantage, and this is as well where we want to marry with the idea of innovation and supporting AI, because with the CE label, this AI can be marketed without any further restrictions in all 27 member states. It's like any other product, like a car or a medical device. Once you have done your conformity assessment, there's no further restriction if you want to go to another market. And therefore, of course, there is a ex post market surveillance to make sure that this product stays safe. So there are, on the national level, market surveillance authorities which will watch. They have a coordination and information exchange mechanism so that we make sure that this internal market stays safe. It's not just a formal exercise you do at the beginning, but there is a certain market surveillance. But the advantage is, once you have the label, you can market and use the AI safely all over Europe.
Okay, thank you. It's very clear. Now it's time to take some few questions from the audience, and we have a first question about the GDPR, and the interaction with the AI Act. And the question is what about, I read it, how do you plan to make it clear for business to implement the EU AI Act regarding, I guess it was on the question, the GDPR implementation. So, who wants to answer this difficult question? I know, but it's important. Laura, maybe.
Take it, yes. Thank you very much. Indeed, so I've mentioned before the GDPR and the AI Act, they will apply in parallel. And they have in principle been designed to be complementary. We will clarify this interplay by providing practical guidance. We're working very closely with the responsible institutions for data protection to make sure that we cover all questions and really clarify the interplay in practical terms for companies.
Okay, do you want to add something about the GDPR? No. We have a second question about the application of the AI Act for specific businesses. Do you have a plan what are the practical steps for specific application for business about the AI Act? I guess the question was about whether you are involved in healthcare or finance or in other specific sector. Do you plan to do something for a specific sector? And
as I said, the AI Act is a horizontal act, so it touches on a lot of different areas, and we deal basically with high risk. That is one of the key features. And high risk in our context means very often as well highly regulated areas. So we understand that there's a certain complexity, because where we look at finance or look at medical devices, these are areas where there is of course already some regulation. Therefore it's very important that the interplay between the AI Act and the sectorial legislation, be it finance, healthcare, whatever, machinery regulation, is really ensured. This is nothing new in the new legislative framework. This is very important to understand, because if you today have a toy with a Bluetooth function, you have to comply, for instance, with the Toys Directive and the Radio Equipment Directive. So this is something operators are used to do. But of course, we from our side have to make sure that this works very well. So in the future, operators will have to make a risk mapping in the beginning, and then they have to see which sectorial legislation and AI Act they have to perhaps apply. But we want to set up groups with the member states. We're working on this. We will already have now meeting subgroups under the AI board, which is our steering board, so to say, where we want in detail to look at these sectorial legislations, and there we will provide even more practical guidance. So for instance, if you have a robot with AI, how should this in practice be organized that the machinery regulation and the AI Act are applicable. But the good news is, which I would like to convey to the companies today, is we will make sure that there will only be, for instance, one conformity assessment. Our objective is that the conformity assessment, for instance, for the robot in the future should as well include then the AI part. We really will pay a lot of attention to the fact that we avoid duplication of procedures.
Okay, thank you. We talk about the GDPR, the new legislative framework, but there is a last question on Slido about fundamental rights. And the question was, will the AI Act require a higher protection level for fundamental rights? Or how does the AI Act relate with fundamental rights?
If I can take that. The AI Act, in a way, enables us to enforce fundamental rights. So the fundamental rights are on top of our value pyramid. But for example, if I'm applying for a job and I'm not taken, I don't know whether I have been discriminated or whether there are better candidates. But the way this kind of AI would work and would be constructed with the AI Act would be that it would be relatively easy to find out what the problem was. And so the AI Act really helps the enforcement of fundamental rights to see in that case whether I have been discriminated.
Okay, thank you. There is no more question from Slido on this part. And so let's turn to the second part of this webinar on the risk-based approach. You just mentioned the pyramid of risk, and we'll talk about that. The risk-based approach is one of the main distinctive features of the AI Act, marking a significant departure from the previous one-size-fits-all model of regulation. So let's delve into this risk-based approach. To start, the AI Act is based on a pyramid of risk. So I want we often present this pyramid as a 4-level pyramid of risks. But also during the negotiation, the release of ChatGPT has transformed the way we conceptualize this pyramid. So my first question about the risk-based approach is for you, Kilian. Could you comment this pyramid? There is a slide on the screen with the pyramid. Could you comment this pyramid in a general way, please?
Well, with a lot of pleasure. The underlying idea of the pyramid, and that is perhaps a key message, is that we want on AI only to regulate as much and as far as this is required by the risk. That is the key idea which is underlying this pyramid. Where there is no risk or limited risk, we only want to intervene very, very lightly. And this is, I think, the biggest point you need to retain from this seminar, perhaps. If you look at the pyramid, what you see is the 4 colors. And there's always, I have to say this, one little thing which is, of course, not correct, which we have just done for the purpose of presentation, because the green layer, basically the layer where you have near minimal risk, is much bigger in reality. In our estimate, these are 80–85% of the AI systems.
Correct me if I'm wrong, but the green part, the no rule, no risk, is not mentioned in the text.
It's not really mentioned in the text. The only thing we have for no rules, no risk, or minimal risk, because there's nothing in life without any risk, of course, is voluntary codes of conduct. But these are, as the name says, voluntary. So for this, and here the examples were, if you look at your smartphone, your app organizing your photos, or your app suggesting you the music in the morning when you want to go for your run, all these things will not be regulated in the future. First thing, perhaps, to retain. Secondly, if you go up a bit, this pyramid, we see, and here you see that's why it's nice pyramid, because these layers get smaller.
Just to be clear, if you're not on the high risk or unacceptable risk or limited risk, you can do whatever you want. You have to respect the GDPR, you have to respect, of course, but regarding the AI Act, you can do, there is no regulation for all these use cases. Do you have some example of use cases no risk, with no risk?
Yeah, absolutely. I mean, the first, if you want to check as a provider, if you're covered, you have to ask yourself 2 questions. First, is what I'm doing really AI? We will come to this. And second, is it minimal risk? And then you're out. And you just have to respect, of course, normal rules. I mentioned already 2 examples, but there are other things like predictive maintenance, what you have in factories. A lot of applications which you use in logistics. will not be covered. So if you move away a bit from consumer used AI, but go more to, let's say, business used AI, a lot of things which basically prepare data, help you to organize your business, that may be AI, yes, but it has no effect on fundamental rights, there's no effect on safety. You can continue to do this. There will not be an intervention from our side.
Thank you.
If you then go up, we have the yellow layer. Here's a transparency risk. Here's important to retain. Here we do not ask you basically to change your system. We don't have quality requirements on your system. But what we ask you to do, the Act asks you to do, is to be transparent that you use AI. And this is meant, for instance, if you use a chatbot, that people know I'm not speaking to a person, I'm speaking to a chatbot. But that means as well, if you synthetically generate content like deep fakes in text, in audio and in video, you have to label them. And you have to label as well text of public interest. And that's quite important in the future. You have to, in a machine-readable way, to introduce tools so that you can detect whether synthetic generated content, text, video, or audio, has been synthetically generated. This should help us in the future to distinguish between fake and real.
Can we say that this layer is horizontal, applicable to all use cases?
It's well, in a way, it's applicable to all generative AI, if you wish. All AI which basically produces some kind of content, which is either text, video, or audio. There you have these obligations, and we think that these are guardrails for digital society, because as well in the future we need to be able to distinguish what is man or woman made and what is synthetically generated.
Okay. So let's move on to the other.
And then we come to the orange layer, which is a bit the core of the regulation, because Laura mentioned very well all the different chapters of the regulation. So most of the provisions concern this. These are the high-risk AI systems. And these are, high risk is a bit perhaps sometimes misleading, because it may sound, don't do it, it's very risky, that's why we have the regulation. We have a lot of high risk products. The car is a high risk product as well. We could call it as well a high impact product. Here we have qualitative requirements. This is where you do the ex-ante conformity assessment, what I spoke about, where you have to check that the product is safe, where you have to control this ex-post market surveillance. But the message is you can do it, because now it will be checked and it will have received a label, and therefore it's safe. And this is a good thing. All AI in Europe, be it low risk, medium risk, high risk, with the CE label in the future is safe, because where it's needed, we will have made sure that the safety requirements have been checked. And here you have these two main categories. You have AI is self-standing, like in recruitment system or admission to university, but you have as well AI, for instance, in a product like in a robot. And then on top of the pyramid, yes.
Just before we move to the top of the pyramid, could you explain the different use cases from the Article 6, 6.1 and 6.2 about high-risk system? There is two different high-risk systems. I'm sure it's not clear for everyone, because it's complex, so it's a point of interest.
I agree. It's complex, but it's important to get it right and not to overdo, and that's what we tried. We have in 6.1, we have two main categories. One is you are a high-risk system if you're a safety component of a product which is subject to a third-party conformity assessment. And the idea here being that if you are subject to a third-party conformity assessment, the sectorial legislator has considered you to be, this product to be particularly risky, and therefore has subjected it to strict rules. Example would be a robot, for instance, interacting with a human, would be a high-risk machine device. Then the AI, subject to a third-party conformity assessment, the AI steering that robot would in the future be subject here to our requirements. That shows as well that there's always one conformity assessment, because you have in any way for the robot, you would have to do an ex-ante conformity assessment, but now you have clear criteria as well for the AI. For the self-standing AI, so for the one in let's say in the more social related systems, we have basically created categories. In Annex 3, we have 8 categories, and we have a whole article where we describe on which basis we have identified these categories. And these range from biometrics to education, to labor, to law enforcement. And these are, let's say, areas which are particularly sensitive to fundamental rights, because very often if you look at these areas, you have a relationship of subordination. You have in law enforcement or border controls, people are vulnerable, and therefore they are exposed to public power, and therefore public power may and should use AI. We are not at all against this, on the contrary, but this must be good AI which is trustworthy and checked, and there we will come in with our requirements.
Okay. Thank you, Kilian. Could you explain what are the relationship between this different level of the pyramid?
The relationship is not mutually exclusive. That's something perhaps we need to explain, except of course the prohibitions, which I've not yet touched on. Prohibitions are obviously prohibited and therefore you shouldn't do it. But you may have an overlap between high risk and transparency. So it could be, for instance, that you use a generative AI in education. In that case, it would be high risk because it's education. In the school, again, students are in a situation of, to a certain extent, of subordination. They're dependent on marks or grades. And it can be generative AI creating a certain content, then you would have to label it. So these things can go together.
There is another category of AI system regulated, is the general purpose AI system. And how this category that not fit exactly in the pyramid will relate with the regulated level of the pyramid, high risk or transparency?
Well, general purpose AI systems have, of course, this distinctive feature that they're general. So they just do not have one purpose, but they have a multitude of purposes. Nevertheless, the rules which we have apply. It means they shouldn't do something which is prohibited. That would be, of course, prohibited. If they are used for a high-risk purpose, they need to be ex-ante conformity assessed. Example, if you use one of the well-known generative AI systems, for instance, for recruitment purposes, to rank your application files, it would become high risk, and then you would have to do the ex-ante conformity assessment. And of course, they're subject to the transparency rules because very often these systems are designed to create content, and then this content should be labeled, and they would need to include technical tools to detect this content as being synthetically generated. So the normal rules would apply. We would need to see what these systems are doing or for which purpose they are used.
Thank you, Kylian. So now let's turn to another hot topic, is the timeline of the application of the text. And so this is a question for you, Irina. The text has entered into force on last 1st of August, but the different provision of the text will apply on a time base from now to 2027. So we have a slide on the screen of the timeline, and could you, Irina, tell us about the application of the text, when the different provision will apply?
Thank you. No, the first thing to apply is if you want the first chapter. So this includes the definition, this includes also literacy, but in particular this includes the prohibitions, and that will apply from February next year. So 2 more months to go. Then the prohibitions and some general provisions will apply. Then we have the rules on general purpose AI, Kylian was just talking about. They will apply from August next year, and by then we're going to have the code of practice. And then we are having the different layers of high-risk AI Kylian was talking about. So we have all the what we call Annex 3 AI systems. And let me be clear, everything which is high risk is explicitly mentioned either in Annex 3 or in Annex 1. So everything which is in Annex 3, which are the self-standing AI systems, they will be applied from August 26. And then we have the ones which are embedded, so the car and the robot Kylian was talking about. This will be August 2027, also for the reason that there really the AI requirements will have to be integrated into the existing conformity assessments. So to get this in place, we thought would take a bit more time.
Okay, thank you, Irina. And the release of ChatGPT in November 2022 shows us that things are changing. So Kylian, is how the AI Act will remain up to date if there is changes in the use cases? Some use cases we will not consider as harmful anymore, or new use cases will raise. So how the text will stay up to date?
Well, to make the text future-proof was a big challenge. And this is, I think, a common challenge for digital legislation, because we regulate a bit. with certain unknowns, because the market and the product change so quickly and develop so quickly that nobody can really pretend to know exactly how which kind of products with which risks will be on the market in 1 to 3 years down the line. We try to nevertheless to be clear, because that's as well very important that we have clear rules, but to have a bit of room for development of these rules, because otherwise the rules may be like a straitjacket. They may be too strict not to take up new developments. Therefore, we have, for instance, taken the new legislative framework approach with the standards. So the standards can be further developed, a very important element. We have allowed for a number of opening elements in the Act, for instance, with delegations and implementation powers for the Commission, so that, for instance, this risk of high-risk use cases, we will have to adapt every year. The regulation foresees that every year we will come up with a report, look at the high risk. Here we work as well with international organizations like the OECD, and we will update our list. We have, Irina mentioned this, we have developed a code of practice for the general purpose AI. That's a co-regulatory approach, as well as something we can adapt. So there may be follow-up codes. So we will try this to do this in dialogue with stakeholders and with the industry, but we will need to develop this a little bit further in order to see what comes up. And these elements all together should help us to make it future-proof.
Thank you, Kylian. And Irina, there is an ongoing consultation launched by the Commission on the 13th of November 2024. Irina, can you tell us more about this consultation?
Yes, actually there are 2 consultations ongoing. I just said that certain rules will be applicable from February. So, and there we will provide guidance just to clarify what exactly will be applicable. And the 2 consultations we have launched on the definition of AI. Indeed, this is the condition for something falling under the AI Act, and also on the prohibitions. The consultation will be open until 11th of December. And basically what we're doing for the prohibitions, we are saying, okay, this is the prohibition, these are the different legal concepts, and we are asking whether anything of this, anything of what is written in the prohibition, people find needs specific clarifications. And then we ask for use cases, like whether they have use cases which clearly fall under the prohibition, but also, and this is very important to us, whether there are use cases where they feel it needs to be clarified, whether it falls under the prohibition. And all this will go then into the guidance, where in particular we want to give many practical examples, what is in, what is out.
Okay, thank you. High-risk systems are at the core of the AI Act. And Laura, could you sum up the requirements regarding high-risk system, please?
Yes, indeed. We introduce obligations both for providers of high-risk AI systems and for the deployers. Providers are those who are developing them, putting them on the market, and deployers are those who use them under their own responsibility. So to give you a very concrete example, provider could be a developer of an AI solution that evaluates CVs, a software tool, sells it, and then you have the deployer, a company that buys this and uses it in their HR department. The obligations, or the core of the obligations lie with the provider. Kylian explained this earlier. This follows with the logic of the product legislation approach. They bear the most responsibility because they are the ones to sell it on the market. They have influence on how the technology is developed. So what they have to do in terms of obligations is to ensure the high-risk AI system meets certain technical requirements. There will be another session where these will be explained in detail, but to mention a few related to data governance, human oversight, accuracy, robustness. These requirements, they are set out in the AI Act, but they will be operationalized through the harmonized standards, which we have touched upon. This is an ongoing process. Right now, the standardization organizations are developing these standards, and then hopefully in the future, providers can follow these standards and trust that what they do is in conformity with the AI Act. Other obligations they have is to put in place risk and quality management throughout the life cycle, They must register the system in a central EU high-risk database, and they also have further obligations that relate to monitoring for incidents, possible reporting, cooperation with authorities. So that's for the provider. For deployers, it's a bit easier. Primarily, they have to use the high-risk AI system in accordance with the instructions of use, make sure that the staff that operate the high-risk AI system are well trained to exercise human oversight, and they have to use representative data, keep logs. For certain deployers, there may be additional obligations, namely for the public sector, because high-risk AI systems used in this field are particularly sensitive. We often have a subordination relation. So they must, in addition, before they deploy this high-risk AI system for the first time, carry out a fundamental rights impact assessment. And the public sector, on top of that, when they deploy high-risk AI systems, they also need to register them in the EU database. This doesn't apply to all deployers, just for the public sector. So that's a bit the overview. And I think in the next seminar, you'll deep dive into the requirements for high-risk AI systems.
Yeah, sure. But just a last question about high-risk system. The AI Act is not complete regarding all the requirements for the high-risk system. There is an ongoing building of requirements in the Sensenelec, with the Sensenelec regarding standardization. We'll talk later about standardization, but could you just tell us more about the standardization and the ongoing process of standardization regarding high-risk system?
Certainly. Just to clarify, the AI Act is complete, so it sets out everything that will apply in the future, but what the standardization does is to operationalize, really detail out how should this be fulfilled. So you have an obligation to produce or to develop an accurate high-risk AI system, but what does it mean in practical terms? What kind of steps do you have to take, and how accurate is accurate? This is what is going to be detailed out in these standards. We have mandated, as the European Commission, the European standardization organizations CEN and CENELEC already in spring last year. Why already so early when the AI Act was only adopted now? Is because this is a process that involves many stakeholders, takes a lot of time. We're now updating this mandate to reflect the final legal text. And the standardizations organizations will then, in the course of next year, deliver the standards. We, as the European Commission, will make an assessment if they correspond well to the legal text and endorse them so that then in the future providers can follow them. And really to emphasize, they are intended as a tool that helps, provides legal certainty and practical guidance. But they also help to keep the AI Act future-proof because they can be adopted, and they ensure that the AI Act is workable because it's a co-regulatory process by which they are put in place.
Okay, thank you. So now let's turn to our second Q&A session. The first question I have on Slido, it's about the prohibited AI system. The Act entered into force on next February 2025, and the question was about how can firms start to prepare for the prohibition in February 2025? How can organizations can now start to prepare?
They can check indeed Article 5 and,
at the beginning.
And if they have a doubt on whether this is something to be prohibited, indeed they can always drop us an email. So no doubt about it. We will provide the guidance before February, that's clear. But in the meantime, if there are doubts, we are happy to help. There are others who are happy to help. Important is that when it's prohibited, that they stop using the system. So in that respect, probably it's relatively easy to have a switch off button.
I think it is very important. It is in the philosophy of the AI Pact. Organization can send you an email, you said, to ask you whether this AI system, this use case, is falling under the prohibited system or not.
Yes.
Yes, and you can answer yes or no, or maybe. Or
No, indeed.
you're not lawyer. You're not.
We are.
Yeah, sure.
No,
sure.
we indeed, sometimes we will also have to discuss the cases internally. If now after this event we are going to get 5,000 emails, it might indeed take a bit longer. But normally, yes, we'd be happy to help. And this is also actually what is included exactly in our public consultation, which terminates on the 11th of December. The question to clarify whether a certain use case falls under the prohibitions or no.
Okay, and the second question is about the cost of the conformity assessment. What will be the cost of the conformity assessment for high risk?
Well, we have looked at this. Of course, this is now a little bit outdated already because we are some years down the line, but we have looked at this very carefully in the impact assessment. So if you want to look for figures, you can look there. You will find some indications. Again, we think what the key point is that we try to align this as much as possible with existing procedures. What I said already is for AI embedded in products, the AI will only require an ex-ante conformity assessment by a third party if the basic device where you put in the AI requires this as well. So it will be part of the overall conformity assessment. And these companies will have already a quality management and risk management schemes because this is normally part, for instance, the medical devices of diligent companies. It may be a bit more demanding for self-standing AI systems that we realize because here is the first time these things are really regulated. Here, nevertheless, we foresee a self-assessment with the exception of biometrics, and the self-assessment should as well help you and facilitate the conformity. So it comes with certain costs, that's true. And we have, last but not least, we offer the sandboxes in each member state, which should help in particular small companies, because one message I would like to get across is nobody should stop in Europe to do and to develop AI and to put AI into their products. We will try with our tools, with the sandboxes, with the innovation hubs, with other tools to help. And we seriously do not want to send the message that anybody should be deterred from using AI.
Could you tell us more about these regulatory sandboxes? It's not well known from all the stakeholders, so can you elaborate on this point, please?
No, it's very important because we wanted always in the regulation to have this balance between regulation and innovation. And in particular for smaller companies, of course, every regulation comes with a certain burden, whatever we do, but this burden can be heavy because they're smaller and they have to go to the market very quickly. And therefore we offer this tool, the sandboxes, which are part of what we call our ecosystem of support. So we have, as a commission, we have set up this system of more than 200 innovation hubs, which really provide practical support, and we have testing and experimentation facilities, and then we have as well the sandboxes. So the contact point will be the innovation hubs for the companies. And if they then go to the sandbox, they will first get qualified legal advice, exactly what Irina was now pointing at. If you have a question, if you don't know, and you do not want to consult a law firm or a consultant, you can go then to the sandbox and they will try to help you. If you need more, then you may be admitted really to the sandbox, and therefore, for instance, you will, under the supervision of the competent authority, be able to test your product. So you have what we call a safe space. You will have a safe space where you are protected and where you get guided, and there you can prepare your product for the bringing it to the market and for all the requirements for the ex-ante conformity assessment. So when you go out, you get an exit report, and that could be a tool for you to show then compliance vis-a-vis the authorities when you have to do your conformity assessment. So it would really take you by the hand and prepare you so that you can, with a minimum hurdle, you can afterwards carry out the ex-ante conformity assessment.
Okay, thank you. And we have a last question about predictive policing. I'm not sure what it exactly means, but some countries use AI for predictive policing. It's a sensitive area question. So will this fall under the acceptable or non-acceptable risks?
The answer is a clear, it depends.
It depends.
So if you now take the scenario of Minority Report, the movie, and you just run a system on the whole of the population, and you will tell people like, oh, this person tomorrow is going to commit a murder, this indeed would be prohibited. So any predictive policing which is running without any facts, without any indications, just in the spirit of mass surveillance, would be prohibited. But certain tools for profiling and for actually helping the police to get facts together would be high risk, which means that they would be allowed, subject to the requirements.
Okay, thank you. There is no more question on the Slido, so let's move on to the last topic, governance and enforcement. This is obviously an important point. The AI Act builds a governance framework, and the first question about this framework relates to the AI office. This is a question for Kilian. Could you, how would you present the AI office, I mean in a broad way, general way, please?
Well, the AI office is, has been set up by a commission decision, and it's part of the commission, but it has, of course, a bit its own structure. And the underlying idea is that the commission will bundle all its knowledge, all its activities related to AI within this office in order to ensure a coordinated and a uniform approach vis-à-vis AI. And this underlines as well for us, this is perhaps one thing to get across, the importance of AI. AI for the Commission is of utmost importance. We want to strengthen, we want to make Europe a continent of AI, and therefore we want to put our efforts together, reinforce them and put them together. So we are growing. We started with basically 60 people and we are now at 80 something, and we want to grow to 140 people with 5 different units. The second thing what we wanted to do here in the AI office is that we want, of course, to be a center of competence and to ensure a high quality regulation and compliance. But we do not only want to be a regulator. That's what you see here on the slide, the 360-degree vision. We want that we look at both in the office, at the innovation part, the support part, as well as the regulation. For us, it's not a success if in the end everything in Europe is safe, but there is no AI, to put it very bluntly. For us, it's a success if we have a lot of AI in Europe, but AI following our values, being aligned to our framework. And that's what is reflected in this structure with Lucy Scioli, which you heard in the beginning, as the head of the AI office. My unit here, AI Regulation and Compliance, basically dealing with the implementation of the AI Act. A UAI safety unit where we have really brilliant experts on AI technology experts, which would bring us, like an AI safety institute, to the top level, top-notch science. We have a unit on AI in excellence, so that helps us to that develop support project under Horizon Europe and Digital Europe, AI for societal good, as well looking in particular at the international dimension, as well as the dimension of the global south. What can we do to not to make AI a dividing issue? And then very important, the AI innovation and policy coordination, which carries out this function which I described, ensuring a uniform approach and putting our efforts together to support AI so that we really achieve this strength in AI which we need. And then we have 2 advisors as well, very important, the lead scientific advisor, which should be an outstanding scientist, and an advisor for international affairs. So that's a bit the setup. And here you see the 3 objectives: to keep the regulation, to have foster innovation and research, and to contribute to international development, because we should not forget, we don't do this in isolation. We do this with our partners, with like-minded partners, and we want as well, as much as possible, to align, and we want as well to persuade others to follow our model.
Okay, thank you. How many people work here?
It's changing by the day, so I need every day to check, because we are growing and onboarding. We have about 85, I would say, today. But our objective is, and that I think is realistic given the size of the task, is to be at something like 140 by the end of next year.
Okay, thank you for this very interesting insight. The European AI board is different from the AI office. And now there is a question for Laura about the European AI board. Is that the structure is at the center of the governance of AI? How could you present the European AI board, please?
The European AI board is our key advisor and counterpart. And by our, I mean the AI offices. It's a member states group. It's set up by the AI Act. It comes together to advise on decisions we take on AI innovation policy, on the implementation of the AI Act, and also to discuss our strategy for the international cooperation on AI. it has a very important role in the governance because this is something we haven't talked about yet, but a large part of the oversight and enforcement will take place on national level by market surveillance authorities in all EU member states. And to make the AI Act a success and to ensure it provides legal certainty and creates an internal market, it's important to coordinate well the approach and ensure coherent implementation. So this is one of the key roles of the AI board in relation to the AI Act, bringing everyone together, discussing the harmonized approach to interpreting and applying the AI Act. The way it's set up is that it's a high-level group with high-level representative from the member states, but there are dedicated thematic subgroups where experts come together, where the different authorities in the future will come together once they have been established and are in place. The AI board is up and running. It's had already its first meetings. The next meeting is just around the corner on 10th of December, very operational and indeed a key platform for us to keep in touch with the EU member states and ensure a coordinated EU approach on AI.
Okay, thank you. And in addition with the AI board, each member state will have its own regulatory body. This local approach allows to take into account the context of each member state and each industry. So how will the AI office will collaborate with all these national regulatory bodies?
There are two dimensions. First, the AI office is the key coordinator for the coherent application of the AI Act. This means we organize, for example, the AI board, we bring everyone together, we provide guidance to ensure the consistent application. We have functions such as putting in place information exchange systems. So that's the coordinative role, and that also applies to coordinating the good cooperation between all of these authorities in the EU member states. So we will cooperate with them closely in this regard. But the second role that we have is we will also enforce part of the AI Act, namely the rules that apply to providers of general purpose AI models, the large, powerful AI models. Here the oversight is centralized at EU level because there are only a handful of these models out there. It's a very novel field. It made sense to have one institution dealing with the oversight for these models. But there's of course interlinkages. When you have such models, they might be integrated into AI systems that are within the remit of what the member states oversee, for example, high-risk applications. So the AI Act foresees certain coordination obligations, information exchange channels, and we are right now in the process of setting them up in close cooperation with the member states via the AI board.
Okay. Okay, thank you. Maybe we can go deeper in this question with the Slido question after. But now let's move on to the compliance mechanism topic, which is very important because AI Act is not soft law, as we all know. Kilian, what will happen if a company, an organization violates the AI Act concretely? When will you start to control the application? I'm sure everybody wants to know this point.
Well, no, you're fully right. It's not a soft law. This is a hard law, if you wish. Of course, our intention is not to punish and to sanction. That's why we have as well the AI Pact. We would like to get everybody on board. We're really interested in engaging, in helping, in supporting. But of course, if there is a non-compliance, there will be a follow-up. And this will be, as Laura pointed out, for the high-risk systems or the prohibitions. This will be the national authorities doing this, the market surveillance authorities, who carry out the ex-post market surveillance, and they have all the powers from the market surveillance regulation, because the market surveillance regulation is fully applicable, and this starts with information requests to providers, requests to modify their systems or to repeat, for instance, steps in the conformity assessment, and it can, in the ultima ratio, it can even lead to withdrawal of the system from the market, or even be combined with fines. We, the AI office, we are responsible for the enforcement of the rules on general purpose AI models, so these very big models which you all certainly know. And like for instance GPT or Claude or Gemini, I don't want to promote now any, just to give you a flair of what I'm talking about. And here we have as well powers under the AI Act. So we can ask for information, we can ask for evaluations, we can carry out evaluations, external evaluations, and we can, ultima ratio, we can as well ask to take the model down, and we can impose fines. So there is a whole package is foreseen. I don't know now to be too shocking. Our idea is not to start with fines. Our idea is to start with a dialogue. But if somebody does not comply, we will make sure that the rules are enforced.
Okay, thank you. Do you want to add something regarding the application, or we have enough time to elaborate on this?
I want to add a point, because you'd mentioned that there would be one supervisor per member state. This will not necessarily be the case. We spoke about earlier that some AI systems will be deemed high risk because they are integrated into already regulated products. For these, the responsible supervisors remain responsible. So in the field of medical devices, the National Medical Device Supervisory Authority remains responsible. There will, however, be one single point of contact for citizens who wish to launch complaints for the cooperation on EU level within each member state. But the supervisory system will include more authorities per member state.
Okay, thank you. So now let's turn to the last Q&A session. We have time for some questions. And the first question is about the relationship between the AI office and national regulatory bodies. How will the National Competent Authority member state be? I think this question, the reason we are seeing a lack of national support structures. I'm not sure it's right, but how will what are the relationship between the AI office and national structure? Maybe the question was, when national structure lack do not have the answers, could you help them or no? Okay.
They do have the right to ask for our support and for information, in particular when it comes to checking compliance of AI systems that integrate AI models, but we also foresee further channels in which national authorities can ask for our support. We do realize that for smaller authorities, this new technology, that kind of expertise that is needed, can be challenging. We are already taking steps now. For example, we've launched an action that's called Union AI Testing Facilities, that market surveillance authorities in the future can access to have support when it comes to testing if they don't have the technical means themselves. One advisory group we are also setting up, the scientific panel, a group of independent experts who give technical advice and support the enforcement. This will also provide support to the national authorities. So we are thinking about ways to make sure everyone has the means to carry out this responsibility, also in smaller member states.
And we have, even just to complement, we have in Article 75 foreseen, for instance, that if the member states deal with systems which are based on large models, then they should cooperate with the AI office, and the AI office should support them. And we organize, of course, this cooperation between the national competent authorities via the AI board, what Laura described in the beginning. So we will make sure that everybody is on the same footing. And the AI office will as well be a support structure, so we will provide guidance, we will provide support tools in order to make sure that everybody, if competent authorities feel we are not sure how to deal with certain issues, we will try to provide their input.
Okay, thank you. We have a second question, maybe for you, Irina, regarding the scope of the AI Act. Maybe it's a more a political question. Why military, the defense, military use cases are out of the scope of the AI Act?
This is a very good question. Actually, when we started discussing the AI Act, defense issues, AI in defense was discussed at an international level in Geneva, and it was subject to negotiations there. So that was initially the reason for us saying, okay, this is indeed a domain where it's much more important to have an international consensus. The world has changed a bit since then, and now probably it would have been difficult to include it, because you know that also national security is excluded from the scope of the treaty, so from all our European activities, but indeed also from the AI Act. Now, national security is a concept that you cannot claim everything as national security, and you can also not claim everything as defense. But when it comes to the defense, where there is also confidentiality and everything, it is excluded. Just one word, we also have dual-use products. So, for example, certain drones or other things that can be used for military purposes, but also for civilian purposes. And for those products, as long as they're not exclusively destinated at the military, they indeed are subject to the AI Act.
Okay, thank you. And there is another question, important question, regarding the definition of deployer and provider. Could you explain what is the definition of provider and deployer? I'm sure it's not clear for everyone. Maybe Laura or...
I'm happy to take it. So the provider is the natural or legal person, so the company, the organization, who puts an AI system or general purpose AI model on the market under their own name or trade name. They don't necessarily need to be the one who have developed the AI system, but they are the ones marketing it. And that makes them the provider of the AI system or general purpose AI model. The deployer is the institution, legal or natural person, so normally company, an authority, another organization, who buys such a AI system and uses it under their own authority. So I gave an example earlier, maybe to give another one to illustrate this really well. Suppose we have an AI system that in the private sector that evaluates CVs or that deals with incoming applications. The ones who are developing it are the ones who are marketing it. They are the provider. The company using it, making it available to their employees, to their HR department. That company is the deployer in the legal sense.
Okay, thank you. And there is another question about the competitiveness of Europe and the AI Act. People are sometimes fear sometimes that the AI Act will stop innovation. Or so. What can you say about this in order that the AI Act will not fear the people, the application will be not too loud and too stringent. So, how can you say? Can you respond to this question?
Well, I think we mentioned already a number of elements in the AI Act, like the support for innovation, the need for clarity. I think it's rather a clear-cut set of rules. But beyond this, I think more important is to understand that the AI Act is in the first place an internal market regulation. So that's where I started. We want to create an internal market for trustworthy AI. And we think this is quite important to understand. So there will not be any more national legislation on this. That's the first good news. You will not have 27 different legal frameworks. So when you develop an AI in Belgium and you want to bring it to France, you don't need to do any adaptations. The AI with the CE label can be promoted there. I think that is very, very important. And second, we have to look at this AI, what we consider as, we clarify. There's a lot of AI which will not be regulated at all. We discussed this in the beginning. But where we regulate, there is really a very sensitive risk. And the problem with technology is if you get it wrong, and we had cases as well in Europe where AI got it wrong in these sensitive areas, be it in, for instance, law enforcement, when police uses it, or be it when judges use it, when these are very sensitive. The effect of mistakes, of failures, would be a very deterrent effect. I'm sure that the uptake of AI would go down if you would not have this kind of trustworthiness. Public authorities will not engage, and we see there is a lot of need, because all our administrations are overwhelmed with tasks. We have all member states have budgetary constraints. We need to get more digital, more agile, so that AI can offer a lot, but then of course to use it and to create this uptake. So we think here we will create a market. We will create a market because everybody can rely now on this AI without fearing a reputational damage. And one message I would like to pass for small companies is that the AI Act will allow them as well to compete with established providers, because we will have now a quality standard. In the end, what the AI Act does is a quality standard. So small companies offering a service to the police, which would normally not really be recognized because the police may be too scared to take something sensitive from an unknown provider, will have the chance now to compete with others, because they can say, my system is safe, it's trustworthy, I've checked it, you can rely on this. So this creates a level playing field and a market. And in that sense, we hope, I think in Europe we quite often, we don't have the cheapest products, but we have the best products, or very good products, not to overdo. And I think in this respect, AI can help. Of course, if we do it together with the business, and if we try to be clear and pragmatic in the setup of the rules.
Okay, thank you, Kylian. And there is a question about the public administration. Will the AI Act apply in the same way for commercial firm and public administration?
Yes, it will.
Yes.
It doesn't treat them differently. Now, of course, if you look, for example, at the high-risk use cases in Annex 3, so meaning those in the sensitive areas, self-standing AI systems, the majority of them treat AI that's handled by public administration, for example, that's used to calculate social benefits, or that's used by judges to prepare rulings. But in principle, there's no distinction between whether an AI system has been provided or is deployed by a public institution or a private one.
If I may add, so the requirements are the same, but indeed in certain cases, and that includes AI systems being used in the public administration, there is the obligation to have a fundamental rights impact assessment before deploying, before using the AI.
Okay, thank you. There is another question about AI literacy. This is an important question because AI literacy obligation from Article 4 will apply from February 2025, so tomorrow morning. So how does the organization can start preparing AI literacy compliance? Who wants to answer?
Well, AI literacy is key, and Article 4 indeed prescribes that providers and deployers should try to train their staff that they are able to carry this out. And this is, of course, a key provision, because we have, for instance, the requirement in the AI Act for human oversight. So there should always be a human controlling this. And we have transparency requirements. And these are only meaningful if the employees, Laura just mentioned that often basically the companies or the institutions will be provider or deployer, if the employees carrying out and working with the AI have a decent level of understanding, because otherwise they will not be able to do this. So it's a key provision. This is, of course, we can only part, and it links very well to what we do today, because it's part one of the three commitments, pledges for all members of the Pact to already engage. So I can only invite everybody to start to work on this. We will have as well, for those who have pledged, another webinar on AI literacy. So we will try to give you more indications how this could look like. But I think it's very important that companies start to reflect on how they can bring their stuff to a decent level of knowledge. The AI Act is here not very prescriptive, that's true, because we basically say, it basically says you have to do this. So we will not try to be overly descriptive, but of course we will try to give you assistance and to guide you a bit what is really expected. And I think it's as well in your interest. And that I would like to say as well from the Commission, we have identified beyond Article 4, because it's not on us, Article 4, beyond Article 4 we have identified skills as a key topic. So we will, when we come out now with our strategy on AI, you will see further actions, what we want to undertake on skills, because we think to upscale and reskill people in companies, but as well outside of companies on AI is one of the key things we need to do.
Okay, thank you. And there is a main topic we didn't mention yet. It's about environmental consequences of AI. What can we say about this important topic of energy consumption by AI model and environmental consequences? Who wants to say a word about this difficult question on environmental? Maybe Irina, or you can answer, all of you. Wow.
No, I can start answering on this, and I'm sure that colleagues have something to contribute. Indeed, that is a key question, and it was also a question that we had during the negotiations. So we know that there is a lot of impact on energy consumption, but at the time when we negotiated the AI Act, it was hardly possible to measure it, which means that I was talking before about the high-level expert group, and indeed one of the requirements the high-level expert group had suggested was the environmental well-being. So this was something we discussed how to put it into the AI Act, but we found it basically not really possible to put this in a legal, measurable way. But now we are doing plenty, now we are having plenty of activities, A, to find the benchmarks, to find the parameter, but B, also in the AI Act there are quite a few provisions where the environmental impact needs to be taken into account.
Maybe to complement indeed this question of how to document and how to actually measure and track it's something that we are also addressing when it comes to the rules for general purpose AI models, because these general purpose AI models, often large language models, are those for which the impact of the training and also the operation later on, the environmental impact energy cost is the highest. And so we're starting here as a starting point. Providers of general purpose AI models are asked to track how much energy consumption is involved in the training and operation of the model. And then going forward, we will be working, and we are asking also the European standardization organizations to look into this, into finding methodologies that allow to have comparable documentation and then have this as a solid basis for next steps of action. But the AI Act indeed has as one of its secondary objectives the protection of the environment. And I think this is something on which we are all pulling on the same string, no policymakers, society, but also the companies, because the current large energy costs are something that is also burdensome on the companies. So looking for ways to decrease them is something which I believe is in everyone's best interest.
And there's an interesting example that here, because you mentioned before the adaptability, here for instance we foresee a dedicated act. So in the end, once we have the methodology, we can put this into dedicated act, and then the legislation can follow the development. So because you asked, this is a concrete example how we see this could work, that we will adapt to future developments.
Okay, thank you for your answers. So we are reaching the end of this webinar. This is only the first part of a two-part series. The next webinar will take place on the 17th of December. The subject will be first on general purpose AI model, standardization and obligation applicable from February 2025, AI literacy, but also other obligation. There is a survey link for your satisfaction, so please fulfill it. I want to thank all the AI Pact, and thank you for your attention, and I hope to see you on the next webinar. Thank you.
Thanks a lot.